Welcome to the College Connection podcast, a podcast presented by the College of Registered Nurses of Newfoundland and Labrador. This is the College Connection podcast.
Welcome to the College Connection podcast, and welcome to our new season in our studio. My name is Kean. I am a registered nurse and a nursing consultant with policy and practice at the College of Registered Nurses of Newfoundland and Labrador. With me is Carpenter, who is also a registered nurse and a nursing consultant with the college. The College Connection podcast is made available for RNs and NPs as a resource to promote good practice and to highlight the importance of regulation in healthcare. Today's episode is privacy and confidentiality, what every RN and NP needs to know. We are pleased to welcome a very special guest, Michael Harvey, Information and Privacy Commissioner of Newfoundland and Labrador. How are you today, Commissioner?
I'm great. Thank you very much, Michelle. It's great to be here with you. Please call me Michael.
Okay, I will. Thank you. And what is the role of the Office and Privacy Commissioner?
That's a great place to start. So the Information and Privacy Commissioner is an independent statutory officer of the House of Assembly. And so that means that even though I'm part of the provincial government broadly, I am appointed by the House of Assembly. I'm independent in that my work is not overseen directly by politicians, and so I'm not subject to political guidance, whether that's by the minister or by MHAs. So I'm one of a number of other statutory officers. People may have heard of the Citizen's Representative or the Auditor General. There's, I think, 6 or 7 of us, and my job is to exercise authorities under the Access to Information and Protection of Privacy Act of 2015, and this is what we're going to talk about mostly today, the Personal Health Information Act. And so those acts, primarily what we do under those acts, what we call our core business, is that if people are looking for information from the government, so this is under what we call ATIPA. People would probably have heard about access to information requests. If they submit an access to information request to the government or another public body, another provincial public body, and they're not happy with what they get back, they can complain to our office and we'll do an investigation. If they feel that they've had their privacy breached by a public body in the province, they can complain to our office and we'll do an investigation. We might make some recommendations. Under FIA, and I'll say FIA a lot, okay? So FIA is the Personal Health Information Act. Under FIA, it's the same thing. If you're looking for your own personal health information, you have rights of access to that under FIA, and if you try to get that from we call a healthcare custodian, this is something I'll talk about a lot over the next little while. If you're looking for information from a healthcare custodian and you're not happy with what they get back to you, or you want to correct some of it and you're not happy with what they do about that, then you can complain to our office. If you feel that you've had your privacy breached and your personal health information, that's a specific term, if you feel that you've had your personal health information breached by a custodian, then you can complain to our office. So most of what we do is related to handling complaints. Now people, I'm in the news from time to time, and so people might think that that's mostly what I do. It's not. Mostly what I do is just our core business is dealing with complaints. But I do have an education and advocacy role under both acts, and that's what I'm doing here today, trying to promote awareness about both of these acts, and in this case, FIA in particular.
Great, thank you. So Michael, how would you define personal health information? Because you just mentioned personal health information and said, that's really important in what you do. So
right. So personal health information has a specific and pretty long definition in Section 5 of FIA, our act, the Personal Health Information Act. But I want to just talk about some aspects of that and just try to, in lay terms, explain what personal health information is. And this is, so when you're engaged in healthcare services, and a custodian, this is a term I'll come back to in a little bit, but someone who is providing you with healthcare services in this province, they may be a custodian or they may work for a custodian, and they collect information about you. in the context of the provision of healthcare services, that's personal health information. So there's a few things that we need to be aware of, and that I think your registrants need to be aware of about that. So first, it's the term personal health information. We need to pick it apart a little bit and say that it's not as limiting as what people might think it is. So personal health information, the specific definition talks about identifying information. So that means that it doesn't have to, let's say, be your name. Your name doesn't even have to necessarily be part of it. If the information that is available could be combined with, let's say, information that someone already has, or could get in, let's say, in the public domain, or could easily get in some other way, then that could end up being personal health information if you could reasonably be identified from that. So this ends up being actually a pretty important issue, because often what particularly researchers or, let's say, companies might try to do is de-identify the data. And then in de-identifying the data, then they wouldn't necessarily be so governed by the Act. Well, we've seen lots of examples where, let's say, there's a data set and there's name and, let's say, postal code, and let's say the healthcare service they received and their gender, and they decide to de-identify that by taking away the name. Yeah, that's not going to work. You can re-identify someone pretty easily just with those other if you had information about age, gender, and let's say whether someone or not has diabetes, and then you had postal code, you can probably figure out who that is, particularly in a lot of our communities.
Right.
So that means that those other fields, even though they don't necessarily contain the name, that is personal health information as well. So the other thing that we need to recognize, we need to pick apart the definition of personal health information a bit more, is that the information, the field, the datum itself doesn't need to be particularly health-y. If it's, let's say that your social insurance number is collected in the context, and it normally wouldn't be, but it might be, collected in the context of the provision of healthcare services. If it's collected in the context of the provision of healthcare services, then it falls under this Act and it qualifies as personal health information. So it doesn't necessarily have to be obviously on its face, health information to be covered by this Act. So those are the key things. It's collected in the context of the provision of healthcare services, and that it is not necessarily a direct identifier, and it could be of a variety of different types.
Great, thank you. And that really helps to, clarify personal health information. Great.
Michael, a majority of our audience are registered nurses. Why is information and privacy specifically important to registered nurses?
So, I think, first of all, let me just say, and I'm biased here because it's my job, but I think, and there's a reason why I was attracted to this job at this particular point. I mean, I am not, like many of the people in my field, I'm not a career privacy person. I came from in fact, my job before this was Assistant Deputy Minister of Health Community Services. So I actually come from a healthcare background, and before that from other types of policy. I'm a policy generalist. But I was attracted to information and privacy because in our contemporary world, privacy is becoming more and more important. And you'll sometimes hear people say, there's no privacy anymore. Privacy's dead. This is not, I believe, it is not true. In fact, that's like saying that in smoggy Britain of the 1800s, that, it's too late, you might as well give up on trying to protect the environment. What's important is these steel mills that we're building. Now, if we give it up on the environment 100 years ago, then we'd be in an even worse state than we are now. But the lesson here is we didn't do enough 100 years ago to protect the environment, and we're in a pretty bad mess now. We need to take those lessons and we need to apply them to privacy. We are in the midst of an information revolution that has transformed our economy and our society, and it's transformed healthcare. Healthcare is now significantly, even compared to 10 years ago, the context, the information collection in healthcare is dramatically different than what it was before. Even when FIA, our act, was written, it was written for an analog healthcare service. And the concept of custodian was a person who, I'm sure you'll be familiar with, used to sit in a registry, right? You used to go get your charts from them, and the person would check them out, and you go, like, was the model, right? That's not the model now. Healthcare information is all around us. It's on my phone, right? It's on your phone. It's on my, well, not this watch, but I do have an Apple Watch. It is a classified health device that is constantly collecting health information. Not necessarily personal health information for the purpose of our act, but it's constantly collecting health information. So we're living in a data-rich environment. Even 10 years ago, when we started to see virtual care emerging, we used to talk in this province, we used to talk about how we were pioneers in the provisions of virtual remote healthcare. As if, and the way that we used to talk about it was, well, we were providing virtual healthcare as a completely different thing from like the healthcare that we would receive here in St. John's to people who were living in rural environments. Now that is not the case anymore. Now virtual healthcare is increasingly integrated with mainstream healthcare, physical clinical healthcare, to the extent that it's happening at the same time. I'll go in and have an appointment with a physician tomorrow, and then my next appointment could be a virtual appointment, and then the one after that is a physical appointment. It's all being integrated, and so it's much more data-rich environment. And so we, registered nurses are the front lines of that transformation of our healthcare service. They are involved in it in a whole bunch of different ways, and people are serious about their health. I don't think people are ready to just give up and say, oh well, I don't care what happens to my health information. People care very much about it, and we certainly heard that loud and clear when our health system was attacked by cyber attackers, and that threat environment, as we call it, is continuing to be severe. So privacy is all that much more important. People are more aware of their rights. People are more aware of their risks than they ever were. And on the front lines, our nurses need to be aware of that. More beyond this, and I think this is something that we'll come back to, our nurses are in significant positions of trust, in the healthcare system, and they are the people when that often the first person and the last person as a healthcare provider that a person receiving healthcare services will see. They're the person often who is who people feel that they can relate to, and they share very intimate moments with, and that's an enormous position of trust, and nurses need to be aware of that special role that they're in and the responsibilities that they have.
Absolutely.
Thank you.
So Michael, for someone who's watching or listening to the topic for the first time, what are some key terms that RNs and NPs should know regarding information and privacy?
Sure. I'll focus on a few, but one I've talked about already. So let's take a moment and define what custodian is, because those are the entities that are held accountable by the Personal Health Information Act. Some of your registrants will work for custodians. Some of them may be custodians. Some of them may not know whether they're custodians or not, and some of them I might not even know if they're custodians or not. So a custodian is and there's a lengthy definition in section 4 of our act. But let's start by talking about some of the examples of entities that are custodians. It starts out by talking about our health authorities. The Newfoundland Labrador Health Services is a custodian. So in general, organizations in this province that provide healthcare services are custodians. So, and that would be NLHS, but it would also be, for example, a long-term care facility that is not NLHS operated. It'd be personal care home. Like if it is an organization involved in the provision of health services in this province, then that is probably the custodian. Healthcare professionals who work for custodians who are employees of custodians are not themselves custodians. But if I'm a healthcare custodian and I work independently or I own a company, then yes, I'm the healthcare custodian. So a nurse who works for NLHS, they're not the custodian, NLHS is the custodian, but the nurse who owns, let's say, a private nursing company that provides healthcare services like, let's say, blood collection or other personal services, they're the custodian. The nurse that they employ is not the custodian. Okay? So now there may be other situations where you've got registered nurses who work for the company, and the company, even though they work for the company does not really provide healthcare services. Okay? Then so we did a report on this relatively recently. It wasn't about nurses, it was about social workers and psychologists, and focused on Key Solutions, which is a subsidiary of Key Assets. I expect that many of your registrants would be familiar with that company. And what we found in that was that Key Solutions was not actually providing the healthcare services. It was the social workers and the psychologists were essentially contractors working, and then Key Solutions was providing them back office administrative support. And so in that case, we found that the social workers and the psychologists were the custodians. So really what we had to do to figure that out was we had to carefully examine the contracts and figure out, well, what did they say, and who's an employee of what, and were these people employees or were they independent contractors? What services was who providing? And so that's why I made the point is sometimes the definition of who is or is not a custodian is not entirely clear. And one of our recommendations in that report, which I talk about, it's in the public domain, is that the contractual relationships between those social workers and Key Solutions should have been clearer. And they didn't really address this topic. And that's often not front of mind for healthcare professionals when they're concluding, particularly in new forms of companies. We're seeing new forms of companies emerging and being intimated all the time. Often, who is the custodian and what are their responsibilities is often not front of mind for people entering into contracts. It really should be, and because our Act says that these things need to be straightened out in contracts and agreements need to be in place. So for that reason, and this is the moral of the story on the custodianship concept, is if nurses who are not custodians, who are employees of a custodian, they still have responsibilities under FIA, and that is the responsibility to know what the policies and procedures of the Act are, because a custodian needs to have policies and procedures. It needs to provide training on privacy under responsibilities under FIA. So nurses need to make sure that they know the policies and procedures, that they do the training, and that the requirements for oaths of confidentiality. So nurses that know that they're not the custodian and work for the custodian have those responsibilities. Nurses that know that they are custodians, of course, have direct responsibilities under the Act and need to know about those. We'll come back to that. And then nurses that don't know if they're the custodians or not, they should talk to the organizations that they're associated with and figure that out. That may require getting some legal advice. Okay. So that's the first concept.
Yes,
probably
perfect.
Longer one.
No, that's great.
I'll talk about two others. Okay, if that's okay.
Yes, absolutely.
So the next concept I want to talk about is the concept of consent. Consent is a very important concept in our Act, and of course, nurses are well aware of the importance of consent. I want to, though, point out that FIA we don't consider to be a consent-based act. There's lots of things that to collect, use, and disclose personal health information under FIA consent is required, and consent is really how the custodian gets the authority to do that. But the reason that FIA exists is to provide healthcare in a modern healthcare system, and also not just the direct provision of health services, but also doing things like, QI and QA and
Yes.
evaluation and research.
Yes.
You need to use PHI, and sometimes it's not appropriate, it's not possible or appropriate to be seeking consent all the time. And so FIA exists to, in recognition of that, to establish the grounds, the authoritative grounds for custodians to do things with personal health information, and then puts guardrails around them.
Right.
Okay, to protect, because there is no consent.
Yeah.
Okay, so I'll give you an example. It is under FIA, a custodian has the authority to disclose personal health information, like including identifiable records here. We're not talking about de-identified information. We're talking about record level,
Yes.
PHI. They have the authority to disclose that to researchers for the purposes of academic research
Oh, okay.
without consent.
Oh.
If the study has been approved by the Health Research Ethics Board.
Right.
Okay,
Sure.
so that's an example so we call FIA an authority-based act for that reason. That there are authorities in there that custodians have, and then guardrails around that. So on the issue of using PHI, then your registrants need to know when they need consent, when they don't need consent,
Yes.
what are the guardrails.
Yeah.
Consent is, I think, I get frustrated, we in privacy circles often get frustrated with what we call consent fatigue. People being asked to consent to things that are not, it's in my view, in many of our view, not really informed consent. I mean, just think about how often, and this is even outside the health system, you're just clicking
Yes.
on things. Have you consented to these
Yes,
terms and conditions?
absolutely.
Yeah.
That's right.
Right, that's not informed consent. There's a broad movement to address that problem.
okay.
Because really, it's, that's not meaningful. And what those consent forms are often do is they're not in the interest of providing protection to the individual. They're in the interest of providing protection, legal protection to the company, right? So in the health sector, I have certainly heard people say pretty bold things like, really, the consenting is often about liability. People will sit down with a consent form, particularly and I say in the research context, but often, as you and your registrants very well know, that the line between the provision of certain clinical services and research is pretty blurry. If you want, and there are certain areas of health where, getting enrolled in a clinical trial is the standard of care.
Yes.
And so people are asked to, they sit down and they're provided with a 24-page document, and often the research nurse or maybe the physician will walk them through it,
Yes.
and initial on each page. I mean, do they really know what's in there? I know this is the ethics board's primarily its responsibility to figure it out, but that's hard enough. But I think all healthcare professionals need to be aware that the health context is one where there's power hierarchies. There's a power imbalance between a physician and a patient, between a nurse and a patient,
Yes.
right? And patients are often receiving care in their most vulnerable moments,
Right.
and they're often confused because of what's happening to them or in pain, and beyond that, sometimes the choices that they're being offered are not real choices at all. Right, what we might call a Hobson's choice. It's no choice at all. If you want the care, then do this, or else you can. I suppose you can just go home, or use something that I have recommended to you is less care.
Yes.
Right. So that's not really a choice. So I think that even in situations where where consent is the authority. I think it's really appropriate for both privacy and ethics reasons. Ethics is not really part of my mandate, but for those reasons, I think it's important for all health professionals to be aware of the challenges with consent in the health context. Okay. So the last context, it's a long answer to this question.
No, that's okay.
The last concept I want to talk about is privacy breaches. These are three diverse kind of concepts that I picked. But I think privacy breaches are important to talk about. Our Act anticipates privacy breaches, and we get privacy breaches reported all the time. We actually don't get a whole lot of, we get most of the breaches that are reported to us, our office, are actually under ATIPA, the other Act. We don't get a huge number of personal health information breaches reported to us. Under FIA, the requirement is to inform our office if the breach is material. Okay, so it's an important breach.
Okay.
And so that means that if the data is particularly sensitive, if there's a lot of people affected, if there is a known risk that that data is going to be misused, or if it highlights a systematic problem in the health authority. So we don't get informed, and then the patient doesn't always get informed and notified if there's a breach. So only when there's a material one, and that's defined in regulations. So we do get breach reporting. There are mandatory elements, but with caveats around it about reporting those breaches, whether to our office or to the individual who's the subject of the information. We see intentional breaches, and we see non-intentional breaches. So almost all the breaches we see are just accidents.
Okay.
And usually, if we get a complaint about those accidents, then what I investigate almost all the time are the custodian, the organization. Do they have the right policies and procedures in place? That's the role of our complaint process of our office, is to focus on, does the custodian have the proper agreements in place? Has everyone done their training? Is the confidentiality oaths in place? Are the right policies and procedures there? That's the focus of our investigation. We don't normally do investigations of individuals who have, it's only when there's intentional breaches. And there are, from time to time, intentional breaches in the healthcare setting, and maybe we can talk about that a little later.
Okay, perfect. Well, thank you. I think the key takeaway from this for RNs and NPs is that they need to be informed, particularly if they're setting up their own, self-employment setting, that they really need to be informed and be well aware of what's required under the FIA legislation.
Absolutely, yeah. And we're seeing more and more registrants in non-traditional roles as well, where they may be working for a company who aren't directly providing health services, so that is really important information there.
Absolutely.
So Michael, how does privacy and confidentiality laws impact the average nurse in an acute care hospital?
Right. So, we've already kind of covered a lot of this already, but one point that I wanted to make in response to this question is that, one of the problems that we hear the most within the healthcare system, and not just from nurses, although I certainly have heard it from nurses, particularly research nurses, but I've heard it from clinicians of all types. Privacy, it's in the way. It's preventing me from doing my job. It's preventing me from sharing the information that I need to share to, do the research I need to do, or to provide the services that I need to provide. What's very important, usually that is based on misunderstanding. I can't tell you how many times I hear that and I say, why don't you show me the part of the act that says that you can't do that thing? And it's usually there are all sorts of authorities that's the purpose of the act, is to provide authorities to do the things that are needed to do in our healthcare system. And there may be some due process involved, right, to make sure that those guardrails, like I said before, the authorities are provided. It's an authority-based act, but with guardrails. But for the most part, the answer is not no, you can't. It's usually yes, you can. And But our act, and this isn't just true here, it's true across the country, this is a common story that we hear, that, and we call it the privacy chill.
Okay.
That because people are often very risk averse when it comes to sharing information, because they think, uh-oh, I'm gonna get in trouble. And if I don't share the information, then I won't get in trouble. Okay?
Right.
But they're serving the business of healthcare. So I think the most important thing to realize is, A, yes, nurses need to familiarize themselves with their requirements, so that then they can get down to the business of providing healthcare, and really they should be guided by their professional sense of clinical judgment and what is in the best interest of the patient. I think that is, really, as long as that's your registrant's guiding star, is what's your clinical judgment, what's in the best interest of your patient, does this make sense to you? Usually that's going to align with the act.
Good, thank you. So, Michael, we have a number of RNs and NPs that have started to open up their own business or started to work in the private sector. So what should be considered by these individuals with respect to privacy and confidentiality?
Right. So the first thing is figure out if you're the custodian or if your employer is a custodian. And once you figure that out, you need to know what their responsibilities are and what your responsibilities are. So it could be the case that they are the employer, this new employer is a custodian, and you are an employee of them, and their responsibility is to have policies and procedures and all that, and your responsibility is to follow them and know what they are. It could be that you're the custodian, and there are other bodies that are referenced in our act that are, for example, an information manager. An information manager, there's two types of bodies in our act that work for and do things on behalf of the custodians. An information manager is one. Let's say they were responsible for running information systems. So if let's say if a registered nurse has a company and buys an information system, and they use that information system they populate that with PHI. It's the vendor of that, and let's say that data is stored in the cloud. That information, that vendor is an information manager. Okay, so that the custodian is responsible for having agreement with the information manager about their responsibilities under FIA.
Well, that's a really good point.
So that, and then there's also different actors called agents. The nurses need to be aware of what agreements they need to be party to under the act, and to make sure that they have those in place. Fortunately, what we have recently developed is a small custodian toolkit. I'm gonna wave it around for our viewers. I know we have some people listening and some people seeing. This is what it looks like. Now, I know that the college is going to make this link available. It's also available on our website. That's www.oipc.nl.ca, and you can find this under resources. But the FIA custodian toolkit for small custodians, and we also have a checklist, this FIA compliance checklist for custodians. This will help outline what custodians need to have, particularly small custodians. It's written for these new companies, or new companies, but let's say a physio's office, or even a family practice clinic, or these are all relatively small businesses. They don't have the privacy capacity of NLHS, which has a big and growing privacy office. They still need to know what to do, and so this is where the small custodian toolkit can help outline what they need to do to be in compliance with the Act.
That's really good. So just, I hope you'll be glad to hear we have shared this small custodian toolkit in our notes from the practice team. Yes. And we're going to provide the link as well with this podcast. So that's really great. And so our listening audience will have access to this. So that's a great resource. So thank you.
So for those registered nurses and maybe NPs who are in self-employment, what are their responsibilities for the disposal and the storage of personal health information, particularly when they're leaving or when they're closing a practice?
Yeah, and this is an issue. I haven't seen it come up so much with nurses, but it's certainly come up a lot with physicians, and for the most part, they're most of them are pretty clear on what their responsibilities are, but we have had some issues, and as registered nurses, increase, and particularly nurse professionals increase the number of their clinics, this can become a bigger issue. So the responsibilities are they need to inform their patients and clients of what's happening, and they need to make arrangements for return of the personal health information, or they need to transfer it to another custodian with the patient or client's consent. Okay, they having an agreement with the information manager is important if the information manager is holding the PHI. And increasingly in our digital environment, then that's the case. But also, even for paper files, it's very common for a custodian to make an arrangement with the company to just take over those paper files. But that agreement does not discharge them of their responsibility. Right. The custodian still remains accountable. Right? When I do an investigation, it's an investigation not of an information manager, but of a custodian, right? That's who gets held accountable. And then if disposal is what's happening to these records, usually per a records retention and disposal schedule, then it needs to be secure disposal. So those are the highlights of what's required.
And when leaving or closing a practice, what is their responsibility if they're no longer in that circle of care? And I guess an example of that would be, if a nurse practitioner orders a diagnostic test, what is their responsibility if now those results come back, but they're no longer in that circle of care?
So I would say that generally speaking, the organization should have policies and procedures to prevent that from happening, right? And should provide information on what to do if it does happen. So first is the responsibility in this situation is usually going to rest on the hands of the custodian too, and that's in this context we're usually talking about a large organization. Okay, but that said, I think it is a professional responsibility of the health professional in question to return that information. So don't aggravate the situation. Don't look at it or open it more than you need to. So minimize the extent of exposure to the information. Don't further circulate it. Return it to or send it to the people inside the circle of care that should have it, and not ignore it. Okay, so it's not. I don't think it would meet a professional standard for a healthcare professional to say, I'm not in the circle of care, so it's just best if I just pretend that I never saw this and delete it without looking at it. I mean, those test results could lead to a medical error, right? And that a person not getting the care that they need. Certainly, we've seen, many of your registrants will have seen the tale of Greg's Wings. This is a story about a young man in Alberta who eventually died with the root cause, I think, was testicular cancer, and they charted. His family made a documentary charting the series of medical errors that occurred throughout it. Most of those medical errors could be traced back to misdirected information. Faxes going the wrong way, or test results not going where they were supposed to. Those are medical errors. It's a privacy problem, yes. But I mean, it's a medical error issue that should be the one that is really motivating everyone in the sector.
Yeah. So I guess, Kelly, if I may, it's using your clinical judgment and following the policies. But if you have a critical value, is using your critical judgment and following up with the client. If that's if they don't have another healthcare professional taking care of them. So.
Yeah, I mean, if you're worried, like if one of your registrants gets exposed to information that they shouldn't have, and is worried that they might get in some sort of privacy trouble for getting that information to who it should be in the best interest of the patient,
right?
Don't worry about that.
Right.
Worry about the patient.
Yes.
There are offense provisions under the Act for intentional snooping and intentional breaches, where there's clear malicious intent. That's clear.
Yeah.
But nobody is getting in trouble for acting in good faith in the best interests of the patient. They're not.
Okay, yeah.
Okay? So that needs to be the guiding thought for all of your registrants and every other health professional.
That's great, thank you.
All right, so that concludes our episode with Information and Privacy Commissioner Michael Harvey. So thank you very much, Michael, for joining us today, and thank you for our listening audience for tuning in to this episode, Privacy and Confidentiality, what every RN and NP needs to know.
This has been a presentation of the College of Registered Nurses of Newfoundland and Labrador.